Sebelum menonton video ini, jangan lupa subscribe YouTube kami dan nyalakan lonceng notifikasi. Terima kasih.
Hello everyone. Welcome back to our podcast, Legislatalk or Legislative Talk. This podcast will be discussing about legislation, science and legislation, and legislative drafting in general. And now we have a very special guest that joining us from Sweden. He is a professor of jurisprudence at Stockholm University from Sweden, and he's also the president of International Association of Legislation, which is an association that promoting science and research in the field of legislation. So we have a really qualified speaker today. Okay, so please welcome Mauro Zamboni. Thank you, Mauro, for attend here with us now.
Thank you to you for having me on your podcast. It's my pleasure and my honor, really. Thank you.
Okay, thank you. And then tonight, as for the introduction, Mauro will have discussed topic, right? The topic about Omnibus Law. This is kind of hot topic in Indonesia right now regarding that we have already enacted our job creation law that considered as the first, but is the very quintessential and controversial Omnibus Law in Indonesia. We have it the first, but it's really controversial, okay? And we kind of discuss it as to from the theory perspective and the practice, of course, and we can compare it a little bit from what the Sweden has practiced or have in Omnibus Law, and also your experience and your studies on that, okay? And then I think we can go through directly to the first question, perhaps from the introduction. Also, this is from you, from your for this conversation is starting by we know that about your article about the omnibus bill, the practice in Sweden is kind of interest us to discuss more with you. So but the first question, so from you, what do you think and what you define what an omnibus law, an omnibus bill? I think it's quite a bill of law, okay. And then the second is, and you have made differences between the superficial and a deep omnibus. What does that mean? Okay.
Thank you once again.
Yeah.
Thank you for having me here. And I must first, before I start to answer your question, I must tell you that omnibus legislation actually is not only a hot topic in Indonesia. Actually, it is a hot topic in many countries. The point is, for example, 3 years ago, we had a huge conference in Israel, exactly because there is many countries which have this phenomenon of omnibus legislation. For example, Israel, Italy. So you are not alone. Don't feel alone for discussing this. Indonesia, you are part of the global phenomenon.
Yes, actually. This global phenomenon.
Yes, that globalization has affected also legislative drafting. So it's really a common problem that many realities, regardless common law, civil law, many realities has exactly. I know the US has the same problem, the UK, all Israel, Italy, and then Indonesia, as you pointed out. So don't feel alone in this. So that's fine. Okay, what is the omnibus legislation? What is an omnibus bill? What is an omnibus law? Actually, here the definition is quite simple, because for omnibus legislation is a term which is commonly used to indicate bills or statutes which cover a number of diverse topics. That is, if for example, in a bill, you regulate the opening hours of a shop, and at the same time, you give money to build a bridge. It's different topics. But then this is the common definition, omnibus legislation. But then I thought a bit when I was reading the literature on the topic. I said, well, but there are two levels of omnibus legislation. I say there is first, that is what I call the superficial legislation, the superficial omnibus legislation. There is the bill or the law that covers different topics, but actually you can see a common function behind it. For example, as an example, I would mention, for example, the budget bill. Of course, the budget bill is the regulation of the state budget for the upcoming financial year. Then, of course, you regulate taxes, but also you regulate, for example, incentives to the farmers. You regulate incentives or tariffs for import or export. Of course, you regulate the diverse areas, but under the surface of being diverse, you see a common framework. So there is actually a reason behind that is, as for the budget bill, as I told you, you have to regulate the state budget, and we know the state budget covers different areas of human lives. So that's why I call it the superficial omnibus legislation, because only on the surface it appears omnibus, because when you study the topic, when you go in the content, you say, okay, there is a common function, there is a common purpose. But also with omnibus legislation, you can instead identify those bills or statutes that regulates diverse but at the same time unrelated topics. That's what I call a deep omnibus legislation. That is the type of legislation that not only cover different topics, but also topics whose regulation do not fall within a unifying functional framework. For example, as you took the example, for example, I will say, if in the same bill, we regulate the opening hours of a shop, and we also regulate the amount of people that you will hire as policemen the next year. There is no common function behind them. You just confligate in the same piece of legislation, the same bill, often for political purposes. You confluate totally different topics. That's what I call the deep omnibus, because then the omnibus character, that is the diversity and the scattered character, is not only on the surface, but it's also under the same bill or under the same law, totally different areas. For example, there is cases where you have a piece of legislation, you regulate, for instance, the criminal charges for tax evasion, and in the same bill, you regulate, you institute a new natural park in a certain region, There is no connection between also in the top, there is no functional connection there. It's really different, and you do it usually for, we'll come later today, for political purposes, we will come. So that's why I thought it was very important to make a distinction, because my interest is not so much on the superficial omnibus legislation, because that is quite normal, and I think it's quite uncontroversial. For, as I told you, the budget bill of a country, of course, it has to deal with different topics. What I think is much more controversial is the deep omnibus legislation. That is when you really regulate in the same piece of legislation with totally different areas of law.
Okay, it's really interesting about your answer that there is a superficial and deep, but the deep omnibus, the note that we have here doesn't fall in the same area of laws, right? And then the omnibus is a global issue, not just in Indonesia,
yes.
But many countries have also faced the same problem. I think
absolutely.
Yeah. So Indonesia was not alone about that issue.
Oh, no. You are in good company, very good company.
Yeah. Okay. But actually, as from the introduction, also that Indonesia is the job creation law that has been enacted in 2020 in the midst of this pandemic, right? But we have enacted such a controversial law that amending around 79 acts that already we have, that amending from 29 acts, and then we have even the 11 cluster, I think 11 areas of regulation that will be regulated in the job creation law. As to for example, that we have about simplification of business licensing, and then the investment administrative sanction, and so wider topic that quite interestingly that many of the scholars consider that this is perhaps doesn't fall about the same function or area. And what do you think about that? That does the job creation law in Indonesia doesn't fall in the same area, or can it be considered as a deep omnibus bill also?
Yes, actually, it's very interesting because I was very curious, and then when you asked me to participate and you mentioned the job creation law, and I went to it, and my first impression, I thought, okay, it appears to be superficial legislation. Then it is not a problematic. It appeared, yes. because they say, well, this is the politicians, as usual, sorry. They say, well, these are the same, it has a common function to create jobs. Actually, when you go deep into the law, at least the further I see, I think it's more of a deep character, because this creation of the job is a very, very superficial and we say very unclear concept. When you get deep into this piece of legislation, you, I think, immediately realize, as far as I understood from the English translation of it, because of course, I cannot read Indonesian, so I could read. But as far as I understood from the English translation, it really deals with totally different areas. And despite the legislator, they attempted to give this idea, well, it has this, like the budget bill has the same function of discussing the financial year of the state, this has the same function of creating the job. Actually, when you look as a scholar, when you look at the content, no, I will go more into the deep. They try to sell it, an idea, as superficial, but it was actually deep omnibus legislation, because it often the areas was not even related, and often the areas there was not a common policy behind the entire, a clear policy behind the entire piece of legislation, a common policy, a common function, beside the vague notion to create jobs. But you know, to create jobs is like to create democracy. You know, it's such a broad concept that it fulfills everything. And that's why I say, despite the attempt of covering it with this creation of job as a function, I will define it as a deep omnibus legislation. That is, the politician took the chance to regulate different areas, some economically relevant, but there are some other which affect instead purely the public administration. It doesn't have even an economic feature. There was part of the regulation I noticed that deal exclusively with the internal regulation of the public administration, how they work, how should be structured, which was not even connected, remotely connected with this function of creating jobs. So, my answer, short answer to that, well, they tried to sell it as superficial omnibus legislation, but as a legal scholar, as a legal legislative study scholar, I will say, looking at the content, is a deep omnibus legislation. That is, it was different pieces of legislation put under the same bill, but which had different functions and different topics.
I think this really interesting point from you is about that from the face of the bill, we can say that this is about to sell the same purpose, which is to create a job. It's an abstract concept, like you said before, that it is need to concretize. But if we need go deep to this bill, but actually it regulates and it amendings a lot of wider topics that doesn't fall at the same function or area of law. I think that's a quite it's a new argument to say that this is the omnibus bill, because the concern in Indonesia about omnibus bill is not only about the size of the bigness of this bill, but also about the content itself, because so many controversial, like you said, that perhaps it might have a lock rolling issue, kind of that things that happen in America. Exactly. As that the thing. Okay, and then we can next to this question that, but actually from this controversial job creation law, that it was annulled and decided and declared unconstitutional by our Indonesian Constitutional Court, and argued it is lack of public participation. It is one of the most key issue of this bill, that it lacks of public participation, because it's enacted amidst in the pandemic in 2020, and the process is kind of really fast, and it's faster than the regular bill would like made if this bill is not omnibus, but it's really lack of public participation, as many scholars said about this. And do you agree that the omnibus bill, or what do you think actually about the omnibus bill may limit that this omnibus bill may limit the public participation due to many topics being provided in that bill?
Yes, actually, it's a very interesting question, because I wouldn't say it's a problem of public participation immediately for me, this deep piece of legislation, because one could say, look, it was enacted by a parliament, so the people are represented in the parliament. The people in the parliament then voted it, even in different forms, in a very fast track. So I wouldn't go from a legal scholar perspective with the same path as the court, because I wouldn't say it's a problem of public participation. I think it's much more deeper problem this type of omnibus legislation creates, is that it does not fulfill one of the requirements that, according to, for example, lawfulers, among the others, is required to having a good and valid legislation, namely that it is comprehensible to the addressees. That is, it was Leon Fuller who started this. He has 8 criteria, but I think it's quite common, taken as a, let's say, a principle among the legislative drafters, or at least the legislative draft and scholars, that you should write a piece of legislation which is comprehensible to the addressee, and it's easy for them to understand. The problem here, the addressees, is very unclear who are the addressees. Moreover, for the addressees, it's very difficult to find the law. I mean, I think one of the basics of a democracy is that me, as a subject of the law, can easily have access. Okay, if I want to do something, is it prohibited or is it allowed? I go in and I check and I'm able to see where it is prohibited or not. By hiding this or by combining this like Frankenstein monsters type of law, you know, even for a legal scholars like us, which are experts, it's difficult to understand what do they really mean. Think most also for the courts afterwards. Usually you have to, in clear cases, you say, well, but this bill was put in the in the system like this, so problem with the legislator. So I think the problem is not so much, I will say, of the public participation, though I totally fully understand the reasoning of the court. But from a legislative studies scholar, I will say here the problem is that legislation should be comprehensible to the addressees, you know, because that's also the basic point of a rule of law and the basic point of a democracy, that the subjects of the law can understand what laws prescribes or allow them to do. When you have offered them this, as I said, Frankenstein monsters of legislative drafting, where you put different pieces, it's very difficult to understand, okay, for me as a, let's say, person who has a shop and I want to know if I'm allowed to have a shop open 3 more hours, what should I go in this? And here they talk about public administration, you know, and you have to go through the law in order to understand. Is very, very difficult. So I think this goes even more, so even a certain point, more fundamental element for the democracy. The law is made for the people. That's for it should be easy understandable by the people.
That's your just point. It just strikes me a lot, because your last word perhaps that the law is made for the people, so the people can read it easily and accessible the law easily. Also, I think is a big point from that actually is, yes, we do have like the public participation issue, but more the deeper issue or fundamental issue, as like you said, that this is about the law should be comprehensive to the addressee, to do what the law for, what the law for, who the law for. Yes. And then that's the whole point, I think. And it is from your information, Mauro, and also from our viewers, like now that the many critics, like scholars like Ms. Fitriani Ahlan Sharif and a Professor Maria Farida, has also criticized that and makes the point, also the same point as what you just said, that the law have lack of the accessibility and the readable. Okay, so the public can. This is the interesting of about the job creation law. We can we have
sorry if
yeah.
Can I add just one example about it? I think it was in the 80s or 90s in Italy. The Supreme Court allowed a person had made some problem, had some cases with the taxation agency, and in the end, the Supreme Court in Italy said, "Look, it's not, despite that there is the rule that everybody should know the law. It said for this person, the legislation on taxation matters on this specific area is in Italy so complex that we cannot expect that an ordinary person understands it. So you cannot accuse this person of avoiding taxation because, and then it was an indirect critic to the legislative draft that said, look, if you write in a very complex way, very chaotic way, taxation law, you cannot expect, that was the Supreme Court, you cannot expect, and despite there is this general principle, you know, that the ignorant, it comes from the Latin, that ignorance of the law is not a good excuse. They say, in this case, the legislative bills were so complicated that you cannot expect an ordinary person to obey it. So just to tell you that is a common problem that we have all around the world, is the comprehensibility of the legislative work.
Okay, the comprehensibility aspect from that, because from the job creation law, we could not easily find what the article is. If you said about what laws regarding this one, okay, we can say that this is in a page, in what page, but we actually cannot say that this what in what articles, because it's so many 79 bill 79 acts that amended by the job creation law is not easily readable from ordinary person, so it's not comprehensible. I think it's a quite really interesting point from you. Thank you. And then for the next question, Mauro, I think in this this is some scholars that at the end of the day that Indonesia actually like adopt this omnibus bill. It can be enacted and formalized in our newly law that has enacted in this year 2022, and then like this new law like the permitted to use the omnibus law, but there is the absent. The law is silent as to in what condition or in what particular situation that we can justify. Okay, you can use this omnibus bill in this situation, but should not use in this situation. So, from your point of view, and in what condition or situation we should and should not apply the omnibus bill, and do you have any caution or suggestion on employing or utilizing the omnibus bill?
Yes, actually, a general idea. For the first, I will always exclude deep omnibus legislation like JCL. Absolutely, because is not only problematic for the let's say it's not only problematic for the addressees, for the common people, because they don't know where it is. So, but it's even more important, it's even problematic for the people who have to interpret then the law, for the judges, for example, because, you know, often the judges have a systemic idea, you know, they say there is a system of law where if the terminology is unclear, the fact that it's put in this kind of law, it means that the legislator meant this kind of things. But with this omnibus legislation, even for experts like the judges, it's difficult to understand, okay, they use this terminology here, but we cannot use the law, the bill, sorry, to better understand what they mean, because the bill then deals 2 articles about this, then 2 articles deals about something else, and then so it's not only difficult. So I will avoid as much as I will absolutely avoid at any cost the deep omnibus legislation. That's the first step, because it is undemocratic, as you said, but also it goes against the very idea of a legal system, actually, that you have a system, you have an area of law, for example, environmental law, you have laws within it, and you understand the different terminology, in particular for the courts, when you have to interpret cases which is unclear. So I will also, it's not only a problem of the public, it's also a problem for the legal actors that then must apply, or it's also a problem for the public administration that has then to apply the law, because they do not really understand what is the purpose and so on. What is the purpose behind of the law, because there are 3,000 purposes behind, because it's different areas. So to avoid at any cost the deep legislation, I will allow certainly the superficial omnibus legislation, because as I told you at the beginning, as an example, the budget bill is a classical example where you have a superficial omnibus legislation, but you have then a clear function. That is, you want to regulate the state finances for the upcoming financial year. The problem is it has to be a clear and delimited function for the legislation. You cannot use broad sense. Okay, this omnibus legislation has to do with job creation, you know. It's like to write, well, this omnibus legislation deals with economic issues, you know, such a broad, it has to be, so I will allow the superficial omnibus legislation as long and as far it is there is clear function which unify all the apparently diverse pieces which compose this puzzle of superficial omnibus legislation, you know, because the problem is like a puzzle, you know. A puzzle has a sense, meaning, as long as in the end you put all the pieces, you have a picture, you know, you have a clear picture. You have different pieces with different pieces, you put at the end. So is the budget bill, for example. It seems that it regulates everything, but once you put it together, it's okay, that's clear. They want to regulate the next financial year, the taxes, the entrances, and the expenses of the state. But you cannot have a puzzle that when you put in all the pieces, there is no image, you know, there is different. So I say, I will allow, certainly without problem, superficial omnibus legislation, as long, I repeat, as there is a clear and delimited function, which is directly, which both the courts and the public can see immediately.
Okay.
Yes, it's not only, I give it the example of the budget bill, but there are other examples. For example, you want to take clear measures against climate change in Indonesia, you know? Then, of course, you have to go in a bit in administrative law, a bit you have to go in economic law and financial law to support, for example, sustainable industry. But behind this, there is a clear idea that is we want to diminish the emission of pollutants. So it is clear. Often, then, it is an omnibus legislation. Maybe you have a piece of criminal law where you punish certain behavior. You have pieces of administrative law, pieces of private law where you encourage, for example, the stipulation of contracts with the industry which have sustainable policy and so on. But behind it, you have a clear idea, okay, we want to diminish the emissions of CO2 in Indonesia, you know. So I say there are several examples of superficial omnibus legislation, which I see them very positive, but it has to be clear. It cannot be, sorry if I repeat it again, in order to create job, you know, which is, it has to be a specific function, as for example, diminish the emission of CO2 in Indonesia.
Okay, I think there's a many important point from what you just said, like this, that literally directly just exclude the deep omnibus law, and then we also in certain types of law we can still use the superficial, but it should be clear and specific the topic or the area, and then it should have the limited function, so we can classify it and we can determine in what this is all about, this law. And then I think why we should exclude the deep legislation, if I may, to make a conclusion that it is an issue of interpretation. Okay, it could make a problem for the legal actors to interpret what the law is. And then the second is also about the issue of what implementation. Does the implementing agency know what the law is? I think is if the law is too much or too wide, to have a wider topic, it's kind of that would have the problem. Okay, that's really interesting. Thank you. And then we can move to the next question, Mauro. I think this is the last. It would be the last. That what should typical and common concern, as you have mentioned that this is not Indonesia not alone about this problem, but it's a global issue on employing the omnibus bill. So what should the typical and common concern should be taken into account when we use omnibus bill in legislative drafting, Mauro?
Yes, as I told you at the beginning, so we close what we started. It's not typical of Indonesia, because omnibus legislation is one of the fields where clearly you see the conflict of two discourses. And so there is the political discourse and the legal discourse, which you can find it, as I told you, in the US, in Israel, in Indonesia, then in Italy, all these countries, in all the countries that have a democracy and the rule of law, you find this omnibus legislation, and is always problematic. Why? I will very rarely use it, omnibus legislation, because it's a conflict of two discourse. We have the political discourse, and the political discourse has, and it's totally legitimate, its paradigm. That is, usually one of these paradigm of the political discourse that you work based on compromise. You know, you want to reach a certain goal, you do a compromise with your opponents, and so you want to reach A, and then you give something to your opponent, and so on. And it's totally legitimate. It's part of the political discourse, you know, that you work, you want to reach certain goals. In order to do it, you do it by convincing the people or compromising with the opponent. But you have this political discourse. But with the omnibus legislation, this compromise seep into the legal discourse. And the problem with the legal discourse, it has a totally different way of working. Law is not based on compromise. Laws either allow, is based on, it's called dichotomy. It's based, either you allow or you do not allow, or you prohibit or either you allow or you do not allow, you know, there is not compromise. You allow a certain behavior or you do not allow. So as you can see, that's the fundamental conflict between the two. That with the omnibus legislation, you see that the political discourse seep into the legal discourse, and in the end, what you do is very dangerous, because in the end you produce bad laws that implement bad politics. The problem with omnibus legislation, that in the end, all are losers, both the political and the legal actors. Because what happens that the political actors feel frustrated because they have this law with the compromise, but they see that it does not produce effect because, for example, the judges do not understand what you mean by this term, and I cannot understand it because it's inserted in a piece of legislation that does not give me any clue how to reason in dark cases or in penumbral cases. On the other hand, so they are frustrated, and the politicians that, look, we have a law, but, and you can see often they claim that it's not our fault, it's the legal actors that are not able to implement it. But the legal actors cannot implement it because it's written in compromise terminology, you know, like these pieces of together. And as a lawyer, you do not understand, because for lawyer, either law is valid or is not valid, you know. And in order to be valid, it has to be inserted in a certain in a certain systematic context. So you have frustration among the legal actors, the political actors, that they see the legislation does not have effect, but you have frustration also among the legal actors that says, look, we cannot apply this kind of legislation. This is not legislation, it's just politics, you know. It's unfeasible in our system, you know. So that's, I think one should avoid as much as possible, beside the example that I told you about the superficial legislation cases, it should avoid the omnibus legislation, because in the end, politicians lose, and also the legal actors lose, because they try to put together two ways of reasoning that collide. You know, politician is fully legitimate, they reason based on compromise. As a legal actor, you say either is law or is not law. You know, either is legally relevant or is not legally relevant. We don't have compromise. We have this dichotomic way, which is typical of the law. So that's why I say I would avoid it as much as possible, because we are all, you are all lose about these kind of things. And I think you can see it, at least in other countries, you can see, because there is really a frustration. The politician talk in a certain way, the legal actors talk in another way, and do not understand each other, and really do not understand each other. So that's why I think it's very important to have studied about the legislative drafting, legislative process, because it allows to show both to the politician and the legal actors what should be done, actually. That, okay, for example, when you send me when I was looking this omnibus legislation, the job creation law, one thing I thought, it was, from a legal perspective, it would have been much easier if they had not 11 clusters in the same law, if they had 11 different pieces of legislation. That would have solved many problems, because you said, okay, here is a piece of legislation on simplification of business licensing. Perfect, I understand. Here is a piece of legislation, is an act or a bill on the condition of investment. You know, then also from a legal perspective, is much easier, because we know, okay, we insert this in this area. If we don't know a term that they use in this cluster or in this hypothetical new bill on condition on investment, we know, okay, it's part of financial law. So we have to put it there in that systemic context. So, for example, this, but I'm sure from a political perspective that would have been possible because we would have needed 11 votes in the parliament, 11 different bills, That's why I say sometimes you see the political discourse, I understand for them it's much better to find a majority for one single bill with all the 11, but that it creates problem for us lawyers that this is a Frankenstein monster. For us, it would have been much better, probably a legislative drafter would have told you, look, present simply 11 different bills because it would have made things much easier. But you see that the conflict between the political idea, because for them it was important to pass this measure regardless of the shape. But for lawyers, the shape is very important, is often decisive, the shape of the law, in order to better understand when to apply it, what does it mean, the terminology. So you see there is this clash. But, and I say legislative drafter can make a contribution in that, also especially to the political actors.
Okay, Mauro, I think the point that you have just made that worthy to be emphasized, that both are a loser, right? Because both between the legislator and the legal actor have the different views on that law. So when the legislator will lose because what they meant by the law doesn't deliver perfectly to the legal actors. So the legal actors, on the other hand, the legal actors doesn't know what the law is. So it kind of interesting. Both are loser in omnibus bill, in a deep omnibus bill. Okay, thank you for this discussion. I think it's really worth to give a different perspective about omnibus bill, because from like your just suggestion about to make the 11 different act is kind of like the new proposal for us, that perhaps it can be considered more. And then for the last for our viewers for this podcast, I urge you all, to the viewers, that you can read the Mauro's articles that title "Absence of Omnibus Legislation in Sweden." May I, if I may, to promote your article?
Thank you.
when
you.
I think it's because this is the triggering articles to make this discussion. Absence of omnibus legislation in Sweden, when legislative drafting affects the political discourse, by Mauro Zamboni.
Yes.
Viewers, you can read it through online. Thank you, Mauro, for this discussion, and for the viewers, don't forget to like, subscribe, and also share this podcast, and we will happy to see you in the next episodes. Thank you, Mauro, and thank you to our viewers.
Thank you, and once again, thank you for the honor of being here. Thank you very much.
Thank you.
Thank you.
See you.
Terima kasih sudah menonton. Jangan lupa like, subscribe, dan komen video ini. Follow juga sosial media kami di Instagram dan Facebook, Indonesia Center for Legislative Drafting.